Okay, we're going to go ahead and start. We have 6 people with us so far. The rest of them have to catch up with us. I have to do a 4-hour webinar for Broker CE for NVAR at 1 o'clock. So I want to go ahead and get through our material and then see if you have any questions and go from there. So we're going to pick up contract paragraph 26. So if you can find paragraph 26, let's discuss attorney's fees. Now, I want to give you a disclaimer. This is not, I'm not a lawyer. I'm not practicing law. This actually will reinforce why people need to talk to an attorney when it comes to this contract. Okay? This is going to be my interpretation of paragraph 26. So if any party breaches this contract and a non-breaching party retains legal counsel to enforce its rights hereunder, the non-breaching party shall be entitled to recover against the breaching party, in addition to any other damages recoverable against any breaching party, all of its reasonable legal expenses incurred in enforcing this rights under this contract. You might remember that when a word is capitalized in a sentence, there is a written definition. So if you will go to paragraph 31 of your sales contract, 31G, legal expenses actually defined in our sales contract means attorney fees, court costs, and litigation expenses, if any, including but not limited to expert witness fees and court reporter fees. So if they have to bring any of these people in, the prevailing party or substantially prevailing party will recover their damages, including those items. So it can be kind of an expense if someone breaches a sales contract. Now, one of the questions I'm often asked, the seller didn't do something they were supposed to. Or they didn't do it the way we wanted to, so the buyer wants out of the contract. They were supposed to do a walkthrough item or a home inspection item, and they didn't finish it before settlement. My buyer doesn't want the house. Can they just void contract and say, no, I'm not going to settlement? Well, let's take a look. You have to go into some legal definitions. I'm going to share with you a little bit. Once again, not practicing law, but when it comes to this breach of a breach, so what is a breach? Okay, a breach means that one party had a duty to perform under the contract and either did not perform or only partially performed that duty. So the seller had that duty to fix this item. They did not do it by settlement. Well, that's still not a reason to get out of the contract. What the court will probably look at is to try to determine, was this a minor breach or was this a material breach? Okay, so if it's a minor breach, okay, might call me from California, you know this sounds something. So a minor breach is they didn't fix some item like the leaky sink in the bathroom. Well, that would be a minor breach, okay? So when a breach is minor, okay, the other party failure to completely perform the performance probably wasn't enough to get you out. So a minor breach, the complaining party still needs to perform his end of the bargain despite the breach. However, the complaining party may have the right to damages, which we would find in paragraph 38. So if you take a look at paragraph 38 of your sales contract, the second sentence says, the provisions not satisfied at settlement will survive the delivery of the deed, will not be merged therein. So paragraph 26 is saying they didn't fix this minor breach to the contract. You have the right to go back and sue or get an attorney to help enforce your rights under the contract. So it's not a reason to void the contract. Now, a material breach, okay? A material breach of the contract is a breach that strikes so deeply at the heart of the contract that it renders the agreement irreparably broken and defeats the purpose of making the contract in the first place. So the breach has to go to the very root of the agreement. So one that I've been dealing with, well, they haven't fixed the septic. They said they did, but they haven't. Was the purpose of writing the contract to get a septic system, or was it to get the house that serves the septic system? So in this instance, that's not a material breach. In my opinion, the party needs to go to settlement, go back under paragraph 38 and clarify if they can't get it straightened out before settlement, okay? Now, a material breach would be if the seller refused to settle. We've had instances here recently where the seller changed their mind close to settlement and said, I'm not moving. I tell them I'm giving them the money back. Well, that's a material breach, okay? An example, maybe a better example would be you go to a car dealer, you order a brand new car, and it's supposed to have fancy hubcaps and a special radio. If the car is delivered and it doesn't have the radio or the hubcaps, is that a minor breach or a major breach? Well, that's a minor, right? You probably still take the car, sue or work out getting the hubcaps and whatever that you agreed to. But if I only delivered you maybe the hood, the bumper, and one seat, and that's all I delivered, well, that's going to be a material breach, right? To the heart of the contract, right? So some of the things that the court might look at to see if there was a material breach with the contract. Did it go to the heart of the contract? Can the other party be compensated for the loss? So in the, you know, if some item was not done, and that's when you do your walkthrough, you say, well, this wasn't done. You try to work out at the table some kind of money if they will allow it, etc. How far along in this transaction? If the seller's done everything else they were supposed to do, and there's one item left that wasn't done, that's pretty far into this contract. Unless it rendered not being able to deliver the house at all, like maybe the house burned down the day before settlement. But what are the chances the breaching party will fix the things later, right? Is the non-breaching party ready, willing, and able to perform? There was a case where the person wrote the contract as is, completely as, taking the property as is, but then they came back and said, but we want you to fix, give us an allowance for the bathroom to be redone and this. And the purchaser reneged on the contract, and the seller reneged, and the buyer sued. And the court ruled that the buyer really wasn't ready, willing, and able to perform because they had put contingencies in rather than as is, and they ruled that the seller won the contract. Won the case. So what is also they're going to look and see what the contract says. So in our contract, we have paragraph 26 and 28. It is addressed, okay? Now, a couple other things about this breach of a contract. If the buyer breaches the contract or the seller breaches the contract, it is not discharged. That contract is not, obligations are not discharged until the court rules, right? So the point being, if you reach an agreement for the breach, get it in writing so that everybody has agreed to what the resolution is. If it's a release of the contract or giving the deposit back, or we had a case where they were saying Okay, seller, you won't sell the house to us. We'll let you out of this, but we want our deposit back plus additional money for our actual damages. And they put a dollar amount. And the sticking point was they wanted the money before they signed the release. And we're saying, no, we want the release and then you get the money. Because without the release, they could still come back and until the court released the liability, they would still carry it forward. So when you're talking to someone about a breach of contract, when you're explaining the contract to them, they may very well need to seek legal advice if they do not understand what they're agreeing to. Okay? Should any tribunal, back to the paragraph 26, should any tribunal of competent jurisdiction determine that more than one party to the dispute has breached this contract, then all such breaching parties shall bear their own cost. I always counsel my sellers, if the buyer is not going to show up at settlement, they are going to breach the contract, causing a default. You still need to go to the settlement. You still need to sign the paperwork. Show that you were willing to also, you are willing to complete the transaction. You don't want to also breach the contract by not showing up at the table. So unless the tribunal determines that one of the parties, substantially prevailing party. So we were discussing this in a case where the buyer got an attorney because they're saying, yes, I defaulted on the contract under paragraph 28, but you didn't really suffer that many damages, okay? Because you resold the property in in 2 days. Where are the damages that equal what we are saying that the deposit equals, okay? So if there's a substantially prevailing party, shall be entitled to recover from any breaching party in addition to any other damages recoverable, the legal expenses, etc. So when there's a breach and you get attorneys involved, it can be quite a lot of expenses. So let's say that they didn't fix one item that was in your home inspection report. And that item's about a $500 item. Yes, your buyer has the right to sue for the breach, but did they do anything that would have maybe been a breach also? Will they be the substantially prevailing party? Because if they sue for that $500 repair and they lose, then they're not only going to have to pay their attorney fees, but they're going to have to pay the other side's legal expenses already. So at some point, they have to decide, is this worth pursuing or not, okay? We have a paragraph B, which is a hold harmless clause for the brokers. In the event a dispute arises resulting in the broker, as used in this paragraph to include any agent, licensee, or employee of the broker being made a party to any litigation by buyer or by seller, the parties agree that the party who brought the broker into litigation shall indemnify the broker for all of its reasonable legal expenses incurred unless the litigation results in a judgment against the broker. So if they think that we're going to sue everybody, we're going to sue the broker, we're going to sue the seller, we're going to, a home inspector, well, when they bring us into it, they're also agreeing that they will cover all of our litigation expenses. So you can see where this could start getting kind of expensive. At some point, do we just say, let's move forward and get over this? Any questions about paragraph 26 when it comes to a breach? So a breach simply means they didn't do a term they agreed to. The court's got to determine whether it was minor. If it's minor, it can be remedied. Then that's not a reason to get out of a contract. It has to be a major breach, which we discussed there quite a bit. So any questions? Okay, let's take a look at paragraph 27, performance. Okay, delivery of required funds and executed documents to the settlement agent will constitute sufficient tender of performance. Funds from this transaction at settlement may be used to pay off any existing liens and encumbrances, including interest, as required by lenders or lien holders. Couple points here. Remember,
Sorry, what section are we at? I got it.
I have just gone to paragraph 27.
Okay, thanks.
Okay. Now, a couple points to remember here. If people have lines of credits, HELOCs, home equity lines of credits, on their property, and they have borrowed against those HELOCs, that is nothing but a second trust. That HELOC is going to be paid off out of these funds, okay, that they're talking about here. And if it's not something they can transfer and take with them somewhere else, okay? So if they needed that additional money to leave this property to buy the next one, they may not have it. So remember those home equity lines of credit, okay? You may have heard me say before, one of the things that I like for my sellers to do when I list a property is to ask for a preliminary title search, okay? Contact RTS or whoever you're going to use, ask them how much they would charge to do a preliminary title search, and that will show us if there's any HELOCs, or maybe there's a lien against the property, or a tax lien against the property. All that stuff is going to have to be paid off out of the proceeds, and hopefully there's enough proceeds there to cover it all. So you don't want any surprises. You also have the interest and taxes and everything adjusted to the day of settlement. So paragraph 27, performance, is pretty straightforward. Any questions about it? Great. Well, let's tackle paragraph 28, because 28 is quite interesting. A default is nothing but a breach. Okay. So a breach of contract can result into a default if it's defined in your contract. So default is built into our contract. Listen to this. If buyer fails to complete settlement for any reason other than default by the seller, okay, default, which is a breach. And remember, we discussed material versus minor. So unless there's a material breach by the seller, okay, where they could not deliver the property to the buyer because maybe they didn't really own it, okay, or there's an additional owner, whatever reason, unless there's a material default by the seller, the buyer has to complete settlement. Okay? They can't walk just because they don't like the way the property was fixed by the buyer, etc. And that one came up. Remember the home inspection addendum removal form, or a septic inspection removal form. It doesn't say that your buyer has to like the way the seller fixed it, okay? What it says is the seller must hire a licensed bonded contractor, okay? And as long as it passed inspections for the work that that person did, then suck it up. I mean, if you want to make sure it's done the way you want, then work out some way where you hire the contractor and they pay, okay? So buyer shall be in default if they fail to complete settlement for any reason, and default is capitalized. So basically, if you looked at law, it would say breach and default are one and the same unless it's added to the contract. It has been added here at the option of the seller, okay? So now the buyer defaulted. So the default would take place at midnight on the day of settlement, okay? So say the buyer can't go to settlement, they need 3 more days, okay? Lender says we need more days. Does the seller have to grant the more days? No, because we also have the clause in our contract, time is of the essence. So at midnight, they have defaulted, okay? They breached the contract, which ended in a default because they did not settle, all right? Then the deposit may be forfeited, okay? At the option of the seller, the deposit may be forfeited to seller as liquidated damages and not as a penalty. Now, those words are pretty important legally, okay? Liquidated damages. There's a benefit for buyers and sellers because with liquidated damages, it limits the amount of the loss for buyers, and for sellers provides a preset amount. Usually the buyers deposit money, okay? But why do they have the words not as a penalty, okay? This is pretty important. The courts will not enforce a penalty, okay? So why do you want a bigger earnest money deposit? You're the listing agent. I put 3,000. They counter back. They want 10,000 as an earnest money deposit. Why? Okay. Well, if you think it's because it's going to be a penalty that the seller gets it if I don't perform, you might be shocked if I get an attorney. Okay, because for damages, okay, damages can be liquidated in a contract only if the injury is either uncertain or difficult to quantify, the amount is reasonable and considers the actual or anticipated harm caused by the contract breach, and the damages are structured to function as damages, not as a penalty. So if you have a $500,000 home, right, and you have it listed, a sale happens at $500,000, okay, and the owner has a $2,000 a month mortgage payment, okay? The buyer defaults. 2 days later, you get another contract for $510,000, okay? $510,000. Well, if I'm a lawyer for the person that defaulted, my position is going to be where are the damages? They got $10,000 more. Their mortgage payment was $2,000. They got $10,000 more, okay? Then where are their damages? I want this money back from my buyer. Be interesting to see what the court would say. Now, if I went to settlement, I signed the paperwork for $500, okay, and we put it back on the market because of this default. I only get $495. Well, then it's pretty easy to see my damages. It was $5,000 plus the mortgage payment I made. So it's not cut and dry. How many agents think that the buyer automatically forfeits the deposit and the seller automatically gets it, so therefore we want a higher deposit? Doesn't necessarily work that way when you end up getting somebody that wants to fight it and sue. So if it's a lower deposit amount, 1,000 or 2,000, and your buyer defaults and the seller is willing to take that and move on, then as a buyer, I'm going to probably sign off on that and say, cost of doing business, I won't make that mistake again. But if I've got a sizable amount of money and there weren't a lot of damages, then I'm probably going to take a different approach. I'm probably going to get an attorney and take my chances for see if they can work something out for me. Okay. Now, it goes on to say, in such event, if the buyer just says, okay, here's the money, and the seller accepts it, okay, does that mean the seller has to accept it? No. Okay. And that's another fallacy that I hear from agents. If you don't settle, you're going to lose your deposit. Okay. Well, maybe, depends on a lot of situations and whether or not the seller will accept that as liquidated damages. Right now in a market where houses sell pretty quickly, multiple offers, although I'm starting to see that slow a little bit, and the seller's going to put their house back on the market, probably not going to be that high of liquidated damages because they'll get another offer. So there's a lot that goes into whether or not I should let my deposit go without a fight. Okay, but if it's a slow market and it may take 90 days to get another offer, and the buyer and seller can agree to liquidated damages be the deposit, I'm probably going to agree to that as a buyer and move on. So they really need to talk to their attorneys to see if they automatically want to just go ahead and call it a day and get the deposit back. Okay. So it goes on to say, if the seller takes it, then the buyer is relieved from further liability to the seller. Get the release signed. Okay. Get the release agreement signed. And the release agreement does state that it kills the contract and there's no further coming back against me in the future. Okay. What if the seller doesn't want to take this as their liquidated damages? If seller does not elect to accept deposit as liquidated damages, deposit may not be the limit of the buyer's liability in the event of a default. Okay, so if I had a $500,000 contract and I know I was lucky to get that, and now the market's showing 480, I may not agree to take a $3,000 deposit. I may say, no, I want more, or I am going to sue. And if I win, you're going to pay all my expenses because this default was a breach under paragraph 26. So a lot goes into the decision whether to take liquidated damages or sue for additional. Okay. And then it goes on to say buyer and seller knowingly, freely, and voluntarily waive any defense as to the validity of liquidated damages under this contract, including seller's option to elect liquidated damages or pursue actual damages, or that such liquidated damages are void as penalties or are not reasonably related to actual damages. Wow. We need an attorney for that one, right? But here's what voluntarily and knowingly means under different laws. Parties acknowledge they have read this agreement, understand all of its terms, and that this agreement is executed voluntarily, without duress, and with full knowledge of its legal significance. Each party to this agreement has received independent legal advice from his or her attorney with respect to the legal consequences of making the settlement and release provided for herein, and with respect to the execution of this agreement. Whenever you send me an email and I give you my opinion, I always say, but it's subject to your client talking to their attorney, because we can't give legal advice. But this means without duress, and that they actually understood what they were doing. Now, the key to all this is all buried in a pre-printed contract in a section that, did they really enter into this agreement? Did they understand what liquidated damages were? Did they understand any of this stuff? So it'd be interesting to see what an attorney could do with this in court if everybody was arguing about the deposit. Okay? So don't automatically say, seller, if they default, you're going to get the deposit. That's not what this paragraph says. The higher the deposit, the more money you're going to get, not necessarily. Buyer, you're automatically going to lose it. Maybe, not necessarily. Get yourself an attorney, discuss it. Okay? Now, if the deposit is forfeited, or if there's an award back here in paragraph 28 of damages by a court or a compromise agreement between seller and buyer, broker may accept, don't have to, but the broker may accept, and the seller agrees to pay broker 1/2 of the deposit in lieu of the broker's fee, provided broker's share of any forfeited deposit will not exceed the amount due under the listing agreement. Might be a reason we want a higher deposit, right? Because if they forfeit it, we get half of it towards our commission, but the broker doesn't have to accept that. They could sue. If you look at the last paragraph of 28, if either buyer or seller is in default, then in addition to all other damages, the defaulting party will immediately pay the cost incurred for the title exam, appraisal, survey, and broker's fees in full. So if you accept the fee as a broker of half of the deposit, then you couldn't go back and sue for your commission. I don't know of too many brokers that sue for, tried suing for their commission for a contract that died, but technically it is in the contract to do. And agents, it says broker, not you, okay? If you go to court as an agent and try to sue for a commission, they're just going to toss it out, okay? It's not your commission, it's always the broker's commission. Okay. Any questions about that part? Okay, next paragraph. If either seller or buyer refuses to execute a release of deposit when requested to do so in writing, and a court finds that such party should have executed the release, the party who so refused to execute the release will pay the expenses, including, without limitation, reasonable attorney fees incurred by the other party in the litigation. Now, an example would be POA and condo docs. Everything was done properly. The buyer killed the contract for POA condo docs. They sent that to the party. They sent the release. And now the seller saying, I don't want to sign this release. I think you're just using that to get out of the contract. I want a better reason. Well, at that point, if I have to get an attorney to enforce getting my deposit back, you're going to be paying the other expenses, okay? If the seller and the buyer get attorneys and go to court, over the deposit, where I should have released it because I had a right to void my contract for the home inspection, and I did it properly, and they won't release it. Now we're talking about additional expenses. And remember, we have in our contract, in paragraph 33, that says if this contract becomes void and no further force and effect without default by either party, both parties will immediately execute a release directing that the deposit be refunded in full to the buyer according to the terms of the deposit paragraph. So they have agreed to execute these releases and move forward. It goes on to say in this paragraph, okay, seller and buyer agree that no escrow agent will have any liability to any party on account of disbursement of the deposit or on account of failure to disperse the deposit, except only in the event of the escrow agent's gross negligence or willful misconduct. If all parties signed the agreement to release the deposit, who was going to get it? And the broker saying no because I want to be guaranteed that my commission is covered or I get some money out of this, that would be an example of willful misconduct. Then they could go against the escrow agent. So, but if I don't have a release signed by all parties as an escrow agent, I am not releasing the escrow, and in that event, I'm not probably negligent or having willful misconduct. I am protecting myself. Okay? The parties further agree that the escrow agent will not be liable for the failure of any depository in which the deposit is placed, and that the seller and buyer each will identify, defend, and save harmless escrow agent from any loss or expense arising out of the holding, disbursement, or failure to disperse deposit, except in the case of the escrow agent's gross negligence or willful misconduct. This will hold harmless for the escrow agents because we have no control over the banks going out of business, etc. Right? If either buyer or seller is in default, then in addition to other damages, the defaulting party will pay the cost incurred for the title exam, appraisal, survey, and broker's fee in full. Remember, who orders the title? Okay, it is the buyer. It's not the buyer's agent. Okay, it is the buyer. So once that buyer contacts a title company and says, conduct this work for me, if they default, they are liable for the cost. Okay, we've had instances where the buyer initiated the work, and then within 10 days, the buyer's agent said, you should really use this title company, and then they go with them, and they don't want to pay the original title company. Well, if the buyer ordered it, they're going to be liable. But if it was the agent ordered it instead of the buyer, they may not be liable. So unless you have power of attorney to do that stuff for people, watch how you order it instead of them. Okay? Any questions about paragraphs 26, 27, or 28? These are paragraph 26 and 28. They really need to talk to their attorney. We can give them the basic understandings of these paragraphs, but if they're going to be breaching or defaulting in a sales contract, they really need some legal help. That's not our job. Okay. Any other questions about anything today? Okay. If not, I'm going to cut it short today because I do have to do a 4-hour broker CE class starting at 1 o'clock for NVAR. Monday, we will have Ask Larry, and next Wednesday, we will be covering paragraph 29 and 30 or whatever if we have time to go further. Okay?
Okay, thank you.
Okay? Thank you guys for
Thank you.
thank you for attending. Yes, you have a question?
Yes. If I want to do as a seller of a listing and I want to represent the buyer, is it just that unrepresented form that I use?
Is it the unlisted property, you say?
No, it is listed.
Then you don't. It's listed with another agent, right?
No, I'm the listing agent.
You're the listing agent.
Mhm.
Then you shouldn't be representing the buyer. You would use the unrepresented party form.
Yeah.
You would check on there that you are representing the seller, and only the buyer signs it.
And that's it. That's all I need to do.
Correct.
Thank you.
Okay.
What kind of form you say? What kind of form?
Unrepresented party form. If you are representing the seller and you have a buyer that wants to write a contract on your listing and they don't have an agent, they have to sign the unrepresented party form. You check that you're representing the seller, and only the buyer signs it.
Okay, thank you.
Okay?
Thank you.
Well, great. I will see you guys then, hopefully on Monday.
Monday. Bye-bye. Thank you.
Have a good day.
Thank
You
you.
too.
Thank you. Bye-bye.
Bye. Thank you, Larry.
Bye.
Have a great class.
Thank you.